Hi everybody, it's Suzanne Granchamp, divorce attorney, author, and coach. Today I'm going to talk to you about why you don't count on the court. But before we get started, just a reminder that this is general legal information and not legal advice. That's particular to the state and the county in which you live, and you need to talk to an attorney licensed in your state and who practices in your county for legal advice. Many of my clients feel a certain sense of safety and leverage, believing they can utilize the court if need be as a legal backstop. If my spouse can't be reasonable, they think, then I'm taking them to court where the judge will make him or her see the light of day. Sounds great in theory, except this is a gross misconception about the court's capacity, willingness, and efficacy. The court does not right wrongs, whether in the context of the marriage, the divorce, or in a post-divorce matter. Asking for the court to help resolve any issue is kind of like playing roulette. You put your money down on a black or red number. The wheel is spun and the ball bounces around, flitting in and out of those little cubbies. For what seems like an eternity, the wheel spins, and it spins, and it spins, and then it spins some more. Finally, the ball bounces off the roulette table, landing on the floor. Too bad, no one wins, and the croupier keeps your money. Welcome to decisions made by the court system. And really, you should have to sign off on a waiver before you're allowed to submit any issue to the court for resolution. The waiver would read something like this: warning, the court never vanquishes a ne'er-do-well, rights the numerous wrongs in a marriage, and rarely holds anyone accountable for failing to comply with discovery deadlines, a court order, or the judgment and decree. We're not in the business of setting the record straight. You will not be vindicated. The judge will never clap after reading your pleadings or when your attorney is done presenting. The decision may follow legal precedent or not. Your order will most likely be written by a law clerk who is both overworked and underpaid. The judge may review and edit the decision, but they're often too busy hearing scores of cases just like yours to micromanage the drafting of every order, with 100 or more cases on their docket. Sorry to burst your bubble, sign here. Why is this the way it is? Well, first, the court will never, ever know all of the facts of your case, let alone your family on a personal basis. The judge isn't coming over to your home for Sunday dinner to meet you and your kids. Further, the judge really can't take time to wrap their arms around your situation at a court appearance. Moreover, kids aren't usually permitted in court, and there are often 10 or 15 other cases waiting for the judge's input that morning or afternoon. The only insight the court will have into you and your family is through the rough sketch presented in the written pleadings, which are submitted to the court prior to the hearing. If a court hearing were an art class, the snapshot of your situation offered by the pleadings would be akin to submitting a smiley face as your homework in place of a detailed portrait, because no court is going to read a 100-page novella of your legal woes. Second, the judge assigned your case may not have ever practiced family law and may only hear these cases as a small part of their overall rotation. Many judges hear all kinds of cases, from civil to criminal, juvenile to probate, and mental health. Even when family court is a standalone and the judges assigned only hear family law cases, you can't count on them to know every last nook and cranny of the law. So submitting a memorandum of law is always best practice, and if you don't, you're betting that the overworked and underpaid law clerk, who has 20 other orders to draft, will find the pertinent statute or case law you need to prevail. Maybe. Third, courts are often swelled with family law cases in which folks don't have an attorney. When this occurs, the court cannot shift part of the workload to the attorneys, who are often required to submit proposed orders, giving the court a head start on drafting a final order. When the court must start drafting from scratch, the legal works are gummed up, slowing the process way, way down. Finally, the court is generally constrained by the boundaries articulated by the law. Most states require the sharing of parenting time, a fair and equitable division of the marital property, and may order the sharing of income between the parties if there's a big difference between the parties' current earnings. That's just how it is, and the court is unlikely to go outside of these bounds. Why? Because it increases the chances that their decision could be reversed on appeal. It also takes a lot more effort to draft the order, because if they end up deviating from the guidelines, they usually have to draft additional written findings to bolster their decision. This all takes more time, more effort, and more consideration, all of which are in short supply. Luckily, 9 out of 10 cases aren't resolved by the court. They're actually resolved by an agreement between the parties. So to the best of your ability, make sure you're a part of this majority and don't count on the court.